Thank you all for coming out on a Tuesday night. I know it's a World Series game, so especially appreciate that. And thank you especially to our judges and the special reserve row. We've got Judge Pro and Judge Duckworth and Judge Sullivan. We've got all kinds of important people. We've got lawyers. We've got lots of first-year students. So welcome to you all. Our speaker tonight is Professor Ellen Deason, sitting in the front row as well. She is going to speak to us about the topic you can see here on the slides. I have known Professor Deason for many, many years because we're both in the dispute resolution world and we both teach civil procedure, so we have spent a lot of time together at conferences, and she's really one of the great writers, great thinkers in our field, so it's a privilege for us to have her here today. At Ohio State, where she teaches, she is the Joanne Wharton Murphy Class of 1965 and 1973 Professor of Law. And I'm going to tell you just a little bit about her, but not to eat up very much of the time. She started teaching at Ohio State in 2003. Prior to that, she taught at the University of Illinois for a while. Prior to that, before she went to law school, she was a marine biologist, so I think that that's a nice claim to fame. And she actually was a scholar in the field of marine biology, wrote articles on that. She and her husband fly planes. She told me she's the, what did you call it? The Navigesser, there you go. So that's her role. She went to the University of Michigan for law school. One of you read up on the bio and already was ready with the Go Blue. She was the editor-in-chief of the Law Review there, so that is quite impressive. After that, she clerked for Judge Harry Edwards, who's one of the best-known judges on the D.C. Court of Appeals. After that, she clerked for Supreme Court Justice Harry Blackmun, so that's kind of impressive. I think after that, she also clerked for someone who was working on the Iran-U.S. Claims Tribunal, which was a big thing quite a few years ago before many of you were born. She's written a bunch of books. She's written a bunch of articles. This particular article that she's going to speak to us about today is a prize-winning article. It was awarded first prize by the American Association of Law Schools Dispute Resolution section, which picked out the very best article in the field of dispute resolution last year, and this was the article. So, I only have one more thing to say before I shut up, which is you all got little slips of paper, yellow or green. Fill them out now, give your best answer on the yellow or green piece of paper that you have in front of you, and before I sit down, I'm going to collect all your papers, so pass them to the middle. That's part of today's talk. With no further ado, Professor Ellen Deason, thank you very much for joining us.
Thank you for that very kind introduction. I'm really happy to be here. See so many of you as well. I think the Boyd School, whoa. What should I do, move it down? Up? Farther from my mouth? Well, this is feeding back to what? Take it out. Oh, clip it on the pants. Okay. We will do our best. Anyway, I want to thank Professor Sternlight. This isn't going to work. It feels as if when I come forward is when it... Professor Sternlight and Professor Nussbaum for being wonderful hosts, and the Saltman Center for sponsoring me. Thank you for participating in the exercise. What is it? Is it the lights? Okay.
If it keeps doing it, we'll just turn it off.
I can speak loud enough, but I think everyone can hear me. It's because it's recording. So I was thanking everyone for doing the exercise. I'm going to turn it off. Should I turn it off? Yeah. That's it. Let's see if this is any better. Okay, great. That's far less distracting. Thank you for doing the exercise. Maybe it's this motion here. For a dispute resolution professor, you have to have some kind of activity and exercise. This is going off. Okay, I'll just project. So today I'm presenting on an article, that I actually hope might bring about a modest change in civil procedure. But I'd like to start with what I consider to be the theoretical framework for the article. It's titled Beyond Managerial Judges, and I should have tested everything first.
PowerPoint?
Well,
You can do it now.
oh, I should turn it this way. Okay,
You should also.
turn it on.
Yeah. That's why it's the navigator.
Yes, right. Okay, now that I've proved my technological skills in multifaceted ways, the title Managerial Judges is taken from a famous article from 1980, it's dating back to 1982 by Professor Judith Resnick, which she called Managerial Judges. And at the time, this was one of the first articles to identify what was an emerging trend toward management roles for judges. And so this article is the foil for my analytical framework. And what she observed was a new role for judges managing cases. And this was both after trial, post-trial, with complex remedies, supervising things like desegregation of schools and prison reform. But what she really focused on the most was the pre-trial phase of litigation. And that was supervising discovery, setting schedules for cases, and of particular importance to my project, judicial involvement in settlement. And she considered that these developments in the early stages of litigation, the pretrial supervision, to be a very sharp break from the norms of American adjudication. And it is true that it's informal, it's off the record, it gives judges access to new types of information that they didn't have before, and there's very little a way to effectively review the lower court judges' work here. So she and other people were very critical of this increase in power and the lack of safeguards against abuse of that power by judges. And I think it is true that this pre-trial management role does confer broad discretion to judges and there are a few institutional constraints. Now, the people who were objecting to this lost that debate, definitely. They were arguing that pretrial management was not compatible with adjudication. But judicial management is today completely expected and totally accepted and commonplace. So that part of her work did not persist. But her framework for analysis is still in use to this day. Because what we tend to do is lump the settlement role of a judge in with this idea of managing and the managerial roles, and we put it all into the pretrial category. So I think that by combining them, this lumping ignores the functions of judges and what they actually do in relationship to settlement. It's true that settlement is pretrial, and it's true that it can serve some of the same docket reduction functions that some of the other pretrial activities do. But in terms of roles, I think there's a really important distinction about third-party neutrals in settlement. One is that they are the settlers in this role. Traditionally, it was in settlement conferences. More recently, it's often called judicial mediation, but that's a very different role from actually managing something. If you think about managing, what judges are doing with settlement is they're initiating settlement discussions with the attorneys and the parties. They're assessing cases. Is this a good case for a form of dispute resolution? They're helping the parties select and choose among different options: mediation, court-annexed arbitration, various different mechanisms that can be used. If there's a court program, they are often referring cases to the court program, whether the parties want to go or not, some courts. And they have to coordinate this whole process of settlement with the schedule and with discovery and the motions that are also going on pre-trial. So I tend to separate these two aspects of settlement. When I say judges too, I'm using that as a shorthand. I'm meaning to include magistrate judges and everyone sort of involved in this process. So Resnick argued for the top contrast. She argued separate managerial functions from the role as a neutral in adjudication. Because she thought that those roles were completely incompatible. Now, as I said, she lost that argument, and I want to move beyond that particular conceptual framework and say that when you look at settlement in a more fine-grained way that separates out what's actually happening, there's a different and I think very real incompatibility, and that's between the role as the neutral in adjudication and the role as a neutral in settlement. And so I want to focus not on management and adjudicating, but on what neutrals are doing when they're adjudicating and when they're settling. So my bottom line is that my argument is that serving as a neutral in settlement should be strictly and structurally separated from the neutral function of deciding cases and adjudicating. And I think that the best way to do this is through an amendment to Rule 16 of the Federal Rules of Civil Procedure. And I know we have lots of civil procedure students in here today, and I'm told that they spent about 5 minutes, but they did read Rule 16. So they know something about it, and then the judges, of course, know it like the back of their hand, as do the lawyers in the room. So we have a wide range of love for Rule 16. Now, when I say this bottom line and recommendation, I tend to get two reactions. On the one hand, I get the, can this really be a problem? Could judges ever possibly do this? I can't believe it. And there are many, many judges that avoid settling cases that they're going to try out of a personal conviction that this is inappropriate. But there's nothing that's constraining them in the rules. And the other reaction, which is often from judges, is, what's wrong with that? I do it all the time. I'm quite successful. Everything settles. So let me turn to some history, because the current concerns that we have roots in the past. And what I did was I looked at judicial writings and I looked at studies about courts, and I identified 4 stages in the development of judicial settlement practices. And they overlap a little bit in time, but the early days were judicial restraint in settlement, and that gave way to a period of growth of very active participation by judges and a lot of enthusiasm for settlement. And then we move into a period of court-sponsored ADR programs, so an institutional growth here. And then finally, I think that today there's increasing influence of mediation in the settlement process. Now, I have a picture here of evolution. I guess this goes, does this work? Maybe not. Anyway, it goes back to, the evolution theme goes back to my biology past, but if you do not like the vision of the lawyer there crouched over the computer, here's an alternative vision of evolution. I'm not sure either one is really applicable to the federal rules, but let's set that aside. So the theme here is an expansion of the role of judges in settlement with great discretion about how they exercise that role. And I want to stress that the rules of the federal rules of civil procedure have followed, not led, during this process. There have been 2 amendments to Rule 16 about settlement, and what they did was they just updated the rule to match what was happening in practice. And the Rule 16 currently authorizes management functions and serving as a settlement neutral with very few limitations. And so I'm going to talk mostly from a federal perspective, but the states tend to follow the federal rules of civil procedure and Rule 16 in particular. Is anyone here from the state court system? Do you have an equivalent to Rule 16?
Yeah, we got it broken down to 16.1 and 16.2 for the family court.
Okay, great. So hopefully you'll forgive my federal perspective. There's too many states. So let's go look at stage 1. This goes back to 1938 when the federal rules were adopted. And at the time, Rule 16 was an innovation. It was actually inspired by the practice in a couple of state courts. And the rule authorized pretrial conferences and encouraged them. And these conferences were designed to complement the new notice pleading and to provide a way to narrow the issues heading toward trial through discussion rather than through formalities of pleading. But settlement was not the primary purpose of these conferences. In fact, the word settlement did not appear in the original Rule 16. Now, we had several decades following this, judges did settle in pretrial conferences, but there were informal constraints on how they did this. The first thing was that there was a general attitude that comes out in the writings at the time of restraint. And judges referred to settlement as byproduct. It was not the main purpose of the pretrial conferences. And they thought that it was very helpful to raise the question of settlement with attorneys. The feeling was that attorneys might be hesitant to propose settlement on their own because it would signal a weakness in the case. And so it was helpful for the judges to urge the parties to settle. Lots of judges would not go any further than that in terms of encouraging settlement. There were judges that were more active, especially in some state courts, but there was a second constraint that was structural, and that was the way the assignment system worked. They typically used what was called a master calendar, and that meant that judges were assigned to particular functions: discovery, settlement, pretrial conferences, trial, and they often rotated. But what this meant was the judge doing the settling was very rarely the judge that was going to preside at trial if the settlement didn't work out. Do you have master or individual calendars?
We have primarily individual calendars.
Individual calendars, okay.
In the family division, there's a strong preference for one judge and one family to preside over the entire case.
Okay, so family court, an exception here.
But we do have different judges here, the settlement portions. Right?
You do, right, okay.
Here's just dock court settlement, here's mine, so it'd be.
So you are already doing what I am going to recommend.
Well, we just, interestingly enough, we started in September for the civil domestic arena, having other judges, it's kind of a mandate, you sit and you volunteer sessions each month to hear settlement conferences for our colleagues, for representative unions.
Here's what I say to you, great. You can be a good example. Well, what I want to stress is that leaving settlement out of Rule 16 was not by accident. There was a lot of worry about settlements, the potential for them to be coerced by judges, and there was a focus on separating these functions for two reasons, and they're the same reasons that concern us today. And one is that it's about neutrality, really. If the lawyers and the parties don't disclose the information, the mediation and the settlement's not going to work terribly well, and the process is impaired. If they do disclose it, then that information can undermine the impartiality of the judge and the integrity of the adjudicatory decision. And so this is a dilemma that has no satisfactory choice. Either you don't say what you really think to the judge, or you do, and then if it doesn't settle, you have to deal with the consequences. And here's a quote from one of the judges at the time who was under this master calendar system and thought that was crucial to the settlement process, that lawyers would feel, rightly so, that no judge could successfully detach himself from the information absorbed during the conference or escape forming views on the merits of the case which might unconsciously color his rulings at trial. So we have back in 1942 a voicing of what really is the same concerns that we have today. Okay, this was generally the situation in the 40s, the 50s, to the 60s. Beginning in the 1970s, there was a perception of a crisis, and this was because of perceptions of cost and delay in civil litigation. And what this did was lead to an increased emphasis on pretrial management, as described by Professor Resnick. And at the same time, there was a switch in a lot of courts to assigning cases to individual judges, and they started keeping statistics, and so there was a lot of pressure to get cases decided, get them off the docket. Many judges saw settlement as crucial to that. If you settle the case, it's gone from the docket. So in terms of administering their caseload, settlement really kind of moved to much more of center stage pre-trial. I don't want to paint it all as docket control because there was a lot of genuine enthusiasm about the potential for settlement. And if you go back and read the judicial writings, they're extolling the virtues of the idea of party negotiation and agreement leading to a superior outcome. Now, in 1983, Rule 16 was amended, and now for the first time it authorizes facilitating settlement as one of the topics for pretrial conferences. But what it did was conflate and blend together the idea of management and settling. You can't really tell that they're separate at all from reading the rule. So they're lumping these functions together. Now, a third phase was institutional, and here's when we have the growth of court-sponsored settlement programs. With these programs, the courts start moving. There had been a lot of experimentation by individual judges, inventing things like summary jury trials. Start moving from this more experimental phase into programs that were sponsored by courts. that applied court-wide. And there was federal legislation that pushed this along, again, because of the worry about expense and delay. There was the Civil Justice Reform Act in 1990, and each district court in the federal system was required to have a local advisory committee of attorneys and judges, and they were supposed to come up with plans to reduce expense and delay of civil litigation. And as part of these procedures, they adopted a lot of case management and tracking procedures, but along with that, many district courts adopted some sort of ADR program. Mediation was by far the most common, as it is today. I think, is it 75% of the federal, I forget the exact percentage, but it outstrips the others by far. And then that expired, but it was followed by the ADR Act of 1998. And now you have federal law requiring every district court to have an ADR program for the first time. So the ones that hadn't before now adopt them. And then, along with this, we again get Rule 16 being modified. Again, just following the lead of what the judges were already doing. It was modified to reflect that they would be helping to refer cases to these programs within their court as authorized by their court. Again, it blends the management and the settlement function, and again, it gives the judges a lot of discretion. Now, I think there's a stage 4, overlaps a little bit in time. But it appears that facilitative mediation is increasingly influencing how judges approach settlement. It's hard to know exactly what's going on. The labels of mediation and settlement conference have sort of traditional meanings, but there seems to be a huge overlap in what happens, and a lot of variation. I think the overlap between the traditional view of settlement conference was involved in evaluation of the case by the judge, and stereotypically a little bit of arm twisting, I think it's fair to say, whereas facilitative mediation is a much different style with the parties participating, and more of the parties are making the decision. Information is flowing from the parties as they talk to the mediator. I think with an overlap and a blending of these styles and people doing different things and similar things, it doesn't really make sense to regulate judicial mediation under one rule and settlement conferences under another rule. And that is sort of the way things have developed, partly because these techniques arose at different times under different authorities. So you have Rule 16, and here we have the local Rule 16.1 and 16.2 about settlement, and then you have programs with ADR and mediation that are completely, usually in a different set of rules. There are very few courts that kind of combine those. And so I think as a first step, let's get all this on the same page. And if we do that, then how should we regulate settlement by judges? Professor Resnick thought settlements management, I oppose judges doing it. I don't feel that way. In contrast, I think that judicial officers have a lot to offer as settlement neutrals. They're trained as deciders, definitely, but many are quite good at settling. And here are some of the things that they can bring to the process. They have to be good mediators too if they're going to be doing mediation, but they bring expertise in legal analysis. They have really high credibility. If they give an opinion about an outcome of a case in the forum, it's much more trustworthy for the parties. They also hold the respect of their office. We refer to it as gravitas, and that's not insignificant in terms of the effect on settlement. And finally, I think for the parties, there's a sense of day in court. that can be quite a psychological satisfaction. So those are some of the reasons that I would say I disagree with Professor Resnick, and I think it's fine for judges to settle. But there are risks, and they are especially strong when the settlement officer is the same person doing the adjudication. And those risks are the risks of coercion and impartiality, the same ones that the early authors of the rule were worrying about. Now, do these advantages up here mean that judges who are assigned to preside at trial would be especially good at settling? They do have specific knowledge of the case, so that gives an efficiency. And in some smaller courts, there might be issues about availability of another judge who you could hand it off to as a settlement neutral. But when you look at surveys of lawyers, they suggest that a judge who's not assigned to the case is just as effective at settling as the judge who is assigned to the case. And they prefer the separate settlement judge because this person comes without the problems of bias by the judge and the reticence of attorneys and parties to compensate for that bias. Okay, let me say a little bit about coercion. This is one of the most frequent objections to judicial settlement in general. Especially lawyers worry about this problem. It's really hard to define the boundaries. And we know that judges are trained to be directive. They make decisions. But that authority can carry over into this informal settlement setting. And so when you look through the eyes of the parties, what appears to the judge to be mere encouragement can feel, maybe coercion is too strong, but let's say heavy encouragement. So here's an example, and this is from a case where the judge said, you better settle because I can make your life very painful. What kind of message does that send? Or, I'm going to take the results of this settlement into effect when I think about fee awards. Or perhaps something a little less obvious. All day long spent in a mediation, and the judge says, you've worked really hard at this, I've put a lot of time in on this, I really, really think you ought to settle. And so now you're the attorney, you go off with the client, and you can imagine this happening on both sides, and the attorney says, the judge is really wanting us to settle. Now I know this settlement doesn't give you the outcome that you want, but I think it would be very unfortunate if the judge felt that we were obstructing settlement. And so I urge you to accept this settlement. Maybe the judge didn't intend it that way, maybe he or she did, but you can see the effect of this. So the source can be, something that the judge says during the conference. You have to also think that it can sometimes come from pretrial decisions, from setting schedules. Maybe not all of this is bad, but we have to be aware that this can happen. Now, the potential for this goes way, way up when it's not just a judge, but the judge that will hear the case if it doesn't settle. That's what gives the coercion its bite. And it turns out that it's hard to have a remedy for this after it happens. If you have just, if you make a motion for the judge to recuse herself because you think that she behaved coercively, well, she might say yes, but if she says no, now you have this judge who not only you think was coercing you, but also has been the subject of your motion. So now you're in a really good situation. And the standards for recusal are not geared for settlement. The main one is that, if the judge has information from an extrajudicial source, he or she is supposed to recuse themselves. Well, what do you think settlement is? Not extrajudicial, so that doesn't apply here. The other thing would be to show a deep-seated, intense favoritism or antagonism, which is kind of rare. There's another case where the decision is that even though the judge had settlement fever, that's not enough to disqualify the judge going forward. So I think that it's hard, dealing with coercion is tough as long as you have the possibility of the judge going forward to make the decision. Okay, I put impartiality in a separate category. And there are several ways that this can be affected. One concern is if a judge evaluates the case and gives an opinion about what the outcome might be. The worry is that this becomes a prejudgment of the case, that evaluation is going to affect the ultimate decision, and that the evaluation was formed without the full presentation through the adversarial system of both sides of the case. Now, there are some who say, well, great, if we mediate instead and don't evaluate, that solves this problem. Well, maybe it solves that problem, but I think it creates even more severe problems. And that's because the parties sharing their view with the neutral are often conveying sensitive information that's not relevant at all to a legal decision. It's not the kind of information that a judge is going to learn in a motion for a discovery dispute or other kind of motion. It can be sensitive, personal, and salient, much more likely to color the judge's attitudes, reactions to a party. Now, the solution here is, well, just be reticent, avoid the risk. We've already talked about how that's going to kind of undermine the effect of particularly mediation, but settlement in general. Now, what I want to turn to is the idea that these risks, so far what I've said isn't so much different from what they were thinking in 1938 and the 40s. But this assessment of risk is bolstered by our new understandings about how prior information affects decision-making and about the way our human cognitive processes work. We've learned a lot about how human brains work, and I think we can all agree that judicial officers are human. So that's my starting place. This knowledge is becoming more and more popularized, and I think it should be something that procedural rulemakers can take into account. Many of you may have heard of Daniel Kahneman's book, Thinking Fast and Slow, where he talks about two systems of thinking. One where we're slow and careful and deliberative, but also that there's a system where we think fast and we essentially take mental shortcuts referred to as heuristics. And I'm seeing our psychology doctor here nodding, so I'm encouraging. Now, another really good book that I want to plug is by Professor Sternlight here with her co-author. And she does a really good job of describing those shortcut heuristics and also the schema that serve as organizing principles for the way we take in new information and how it affects our thinking. And so I'm not going to give a full lecture on psychology, but I want to mention a few of the principles that I think are really relevant when it comes to combining settlement with adjudication. So we talked about the worry of the preliminary evaluation. It has a name. It's called confirmation bias. We're going to seek information that confirms our existing beliefs or our expectations. So you probably can't read the caption, but it says, I'm happy to say that my final judgment of a case is almost always consistent with my prejudgment of a case. So I'll say no more about confirmation bias. Another form of persistent effects is called anchoring. And this especially relevant for settlement because it concerns numbers. And what it boils down to is that we're influenced by the first number we hear. Even if we know that it's completely irrelevant, that exposure will affect our judgments, and it's really hard to defend against this tendency. So here I want to call on Aubrey for the effects of the exercise. You had two different color sheets. One asked if the average annual temperature in Las Vegas is greater than 598 degrees. One of the faculty members at noon asked me if it was a typo, if there should be a decimal point in there. The other one asked if it's below minus 20 degrees Fahrenheit. And so this was an attempt to anchor you with a high or a low number. And so the question was, you know, what was the answer to the question? Is it above 598? No. Is it below minus 20? No. Is this at all relevant to the average annual temperature in Las Vegas? No. Was there a difference at all between the groups?
Yes, so the average for yellow was 99.5 Fahrenheit.
And which was yellow,
That's the higher one, so it's going to be the 598 number.
99.5?
Yeah.
Okay.
And then the one for below -20, that was 88.3 degrees Fahrenheit.
Okay. So still too high. You know, I looked it up and I wrote it down and I didn't bring the piece of paper. It's either something like 67.5 or 69.5. Okay, 69.5. So the summer is more meaningful to you in the day than the winter at night, I guess. But the key here is the difference between the two groups. That seeing minus 20 pulled you down. The faculty were about the same amount above and below the 69, which I thought was really interesting. So their crowdsourcing was a little more accurate than yours, at least on the low end. You've lived here longer, okay. So, you know, what this is meant to demonstrate the idea of anchoring, that you knew those numbers were ridiculous, but they still pulled you. So, this is consistent with an experiment that was done with magistrate judges about settlement conferences. And the idea was, what it demonstrates is that the settlement demands can raise or lower the damage awards. They were given a scenario to read about a nasty car accident, and they were asked, and a description of a settlement conference, which was not successful. So then the judges were asked, how much would you award the plaintiff in compensatory damages? Now I've put up the example from the high anchor. The group that got the anchor was told that the plaintiff had demanded $10 million. The other group wasn't given a number, they were just told that the plaintiff had made a significant monetary, demand for a significant monetary payment. And when you look at the averages, the judges that received that high anchor awarded more than 3 times the damages of the control group. I didn't put it up here on the slide. There's a similar experiment with a low anchor where they told them that the demand was $175,000, and the anchor group gave half the amount of damages. So very practical consequences from this cognitive illusion of anchoring. Okay, and what I want to suggest is important is not just settlement offers, but that particularly in mediation, the judge is getting a lot of information. The parties are talking about their interests. They're talking about how much money they need for their medical expenses. They're making concessions. They're talking about why they're making concessions. They may be saying what their bottom line is. They're certainly talking about why the case is strong or significantly weak. And then in addition to what the parties are saying, you have the judge's impression. How much are they cooperating? How sincere are they? How much are they really involved in the process? And so, judges tend to think they can compartmentalize. And so one response is, well, we do this all the time. We have to ignore evidence that we've decided is inadmissible, yeah, they do, but what we're learning about mental processes suggests maybe not as well as they think they do. But even, I don't want to offend anyone, but even if we say, okay, evidentiary rulings, you can ignore what you heard, I think that the nature of the information that comes out of mediation is much, much harder to ignore. And so we can put a label on it. It's called mental contamination, belief, perseverance. We can kind of sum it up as a difficulty in deliberately disregarding, which means it's really hard to ignore information, even if we know it's completely irrelevant. And even if the judge consciously sets it aside, it's in I guess it's subconscious, not unconscious. I'm not sure of the real distinction there, but it's going to influence attitudes and affect inferences. So even if there's a trial and evidence, how that gets interpreted is through this lens here. Now, what should we think when a judge is really confident about putting this information in boxes? There's a brain with lots of compartments, and we're going to put the settlement in one compartment and the evidence in another compartment. Here's a quote from a magistrate judge. When I was in private practice, one of my sensitivities about a judge getting actively involved in the settlement process was a concern for whether he or she could put aside what was said in mediation when it came time to decide the case. In my own mind, I'm confident that I can do that. Okay? So here's someone who worried about this, but now the shoe is on the other foot. So my answer is, if someone is that confident about being able to separate this information, we should give it another label, overconfidence. And perhaps there's some egocentric bias here, but overconfidence is a pretty easy one to see, I think, in this category. And so I believe that judges cannot be trusted to evaluate their own tendencies when it comes to the influence. That must be a judge, right? When it comes to the influence of settlement information. I was hoping I'd get a reaction sooner or later. Okay, so what can we do about this? One option is to revise the ethical codes and say that it's unethical for a judge to preside in settlement and then go on to adjudicate the case. There was an attempt to do this the last time that the ethical rules were revised. The ABA section of dispute resolution put forward a proposal. It was rejected. And so there are a number of reasons why it might not be the best solution, but in any event, in terms of practicalities, it's failed in the last few decades. So I think that the best solution here is to create a structural separation between the settlement and adjudication. And this would be consistent with the way that ADR programs tend to be structured, and also with confidentiality rules. So if we did this, what would a structural separation look like? First, I suggest that settlement should be sent to a settlement judge or a mediator and not done by the judge who's assigned for the trial and the pre-trial decision-making. And I see another reaction in the back. I'm going to hope you ask a good question about this. And secondly, I would say that there should be a limitation on communication and reports. That only limited information about that settlement process should reach the judge who's assigned for trial. It would be fine to report that there was a mediation or a settlement conference, maybe who was there, if the case settled or not, but none of the details about it. Now, the objection is This isn't practical. No judge would want to work on my case. I think it's a matter of will. And people set up buddy systems, as we heard here, to trade cases. There's even been a radical proposal that in small towns where there may not be many judges, that you could have a buddy in the state court, trade with a buddy in the federal court. That seems quite radical to me, but I think it's, as I say, a matter of will. I also think it would be good to change the way that statistics are reported so that people get credit for this work. Although if you really had a buddy, maybe in the long run it would kind of even out. Now, what about potential exceptions? One possibility is to say we wouldn't do this if it's a jury trial. Because there, the problem is of impartiality is not as severe. The judge is not the finder of fact, it's the jury. I argue that there should still be a separation. One thing is that the judge goes on to continue to make important decisions about the case. There's evidentiary decisions, there are post-trial motions, like a motion for a new trial. The deciding is not over at the end of the settlement conference. The other thing is that there's a fair amount of work suggesting that judges have influences on jurors, that the expression on the face is something that the jurors are very sensitive to. The way the judge reacts to the witness, to the parties, sends signals to the jurors. So let's be safe and just say it doesn't matter whether it's a bench trial or a jury trial. I think there's a stronger case for the parties wanting to have the same judge. So maybe a judge who's really good at settlement. I would say we should not call it party consent, but party request. This should not be at the suggestion of the judge, because to me that goes back to the coercion point. In a sense, it's inherently coercive to say, gee, I'd like to be your settlement neutral. No, Judge, we'd really rather not. We don't think you'll be very good at it, and by the way, you can just imagine. I also think that perhaps it would be good to have an opportunity for these parties who request this, after they see what they've said, how things have gone in the conference, to have another chance to say, let's continue with this same judge, or maybe we shouldn't. So, in conclusion, I would say that perhaps it's time for the federal rules to lead, or maybe to say to follow the enlightened judges who have adopted this system, and that it would be good for the rule makers to consider this. I think the problem is that judges naturally do not want their discretion limited. I would argue that you need discretion when you need case-by-case consideration, and that this is a situation where we can apply these principles and say, as a general rule, we should not have judges settling and judges adjudicating. That deciding and settling should be separate functions. And I really think that this will enhance not only the effectiveness of the settlement, but also protect the integrity of the courts, and that the parties will feel more confidence in the justice of a system like this. So let me stop here and ask if there are questions and reactions. There's about 8 minutes left. Yes.
I did have a couple of questions, but I'll just ask one. First, thank you for your very fine and interesting presentation, and thanks to Professor Sternlight and Usbaum for bringing you out for this, because I think it's always important that we consider these kinds of issues when we're involved with the courts. So I'm glad my colleagues are here from the state court, and I'm a retired judge from the federal courts. But one thing that a couple of things that jump out at me. The point that you made about separating the adjudicating judge from the settlement judge is, I think, to the three of us, obvious. In practice in the District of Nevada, that's all I can speak to. That has been the norm. I was 8 I was the only magistrate judge, so I was able to do settlement conferences for my district judge colleagues, but they never did each other's. They would always use the magistrate judge. When we now have 8 in the district, they exchange. They don't, the judge, the district judge, and the magistrate judge are team in a case. The magistrate judge will do much of the so-called managerial stuff Bob Peckham was talking about in his article, and Judy Resnick in response back in the early 80s. And as you'll recall, she continued to talk about the magistrate judge's system and its evolution. I exchanged articles with her on that topic as I chaired the magistrate judges committee for the judicial conference. And those functions are distinct and they need to be. But I agree with you completely that the federal rules follow the experience. They did in 1938. They have every iteration, even discovery of use or e-discovery, reflected what's going on in the world. So did the evolution of the magistrate judges system, so did the adoption of the MDL rules for long history cases, so did the Civil Justice Reform Act. The Civil Justice Reform Act in 1991 was profoundly important within the federal courts, and you touched upon this, because it required districts to have, all 94 districts, to have an ADR system. And here in Nevada, we weren't sure what we were going to do. So we visited and brought in experts from the Northern District of California, Bob Beckham's district, from LA, where they were doing arbitrations, from other districts that were doing mediations. They did E&Es, or individual evaluations, in the Northern District. We opted for the E&Es, not because we have a huge array of neutrals, but because our magistrate judges were able to perform that function because we had many of them. So I think that and I realize your research would go to many of the federal districts and many of the state courts, but in my experience, I think there is a very broad recognition within at least the federal judiciary, that's all I can speak to, of the virtue of this separation. I don't think there's, have you seen pushback in terms of rules amendment? You're familiar with the rules amendment process, I know. And it's a time-consuming kind of experience. It takes time to make some of these changes. But I think the two proposals you put together are very sensible. What have you found in reaction to either your paper or when you were doing your research, other than a few judges who might say, oh, I can compartmentalize, which is silly. It can't.
Right. Well, I'm attempting to be practical and not just, and I'm also not trying to say the sky is falling. And I'm told that in order to get an amendment to the rules of civil procedure, you pretty much have to have the sky is falling to get the attention for something like e-discovery. Now, I mean, in Ohio, in the Southern District, the federal judiciary is split. There are some who agree entirely with you. They would never try to settle a case that's assigned to them.
I forget his name, you had the judge who started the short trial, the fast trial.
Yeah, he was in Northern
District.
the summary jury trial. But there are other judges who see no problem with this. And so, I'm not, who knows what will happen with Rule 16, but I also think that another avenue would be adoption of local rules, as your state court here has done, to accomplish the same thing.
And the local rules I do, maybe that's a fruitful area to consider, because each of the 94 districts federally have a local rules.
There are actually local rules, well, many are silent. There are actually local rules that explicitly authorize judges to settle cases that are assigned to them.
Really?
Yeah.
Wow.
Yeah. So I think everyone's shaped by their own experience, and as I signaled earlier,
My example with the District of Nevada, I can't speak to every other district.
Right.
But
I think there's a huge variation in attitudes and in practice, to answer your question. Other folks? Yes?
I think, I agree with what you said. I think also the thing, there's a chilling effect if it's a judge adjudicating the settlement, because the parties are going to be as open on that, but I think also there's appearance. If we're a settlement thing, and then I rule against adjudication, they're going to think that maybe they pissed me off during the settlement, or I'm biased, for this or that, so to give a definite chilling effect, because you want them to be open, say what they want, and then number two, you get the appearance that maybe what happened to settlement impact adjudication, whether it's true or not, they leaves a bad taste in people's mouths, especially in family court. These people have an ongoing relationship, they need to feel at least, the judge might be stupid, but at least it was fair.
Yeah, okay, so let's hope the judge isn't stupid, but at least he or she was fair is really, really important. And so even if the judge is quite confident about, that they can do it, what matters is what the parties and the lawyers think. And I think you're absolutely right that it's just so easy to see the appearance there. Any students with questions? Be brave, yeah, right.
If states enact this structural separation or ethical codes, if that becomes more prominent throughout the United States, do federal courts ever follow suit?
Oh, interesting. So, well, one example I can think of is back at the very beginning when settlement conferences were put in Rule 16. It was an inspiration from some of the states. Detroit, Cleveland, I think Boston may have pioneered the whole idea of a pre-trial, meeting before trial. Because before then, they wouldn't have ever even seen each other until the trial. So it's possible. One would like to think that the enlightened states could have an influence.
So is that your aim to help, like?
I guess my aim is this is sort of what I think of as, you may hear this term at some point, Brandeis brief, where you just make all the arguments you can as strong as you can and hope that something comes from it. So, anyone else? Yeah, one more, and we're getting over time, and there's that baseball game. So.
Will this add economic costs and just more time considerations? Just because you have this separation, will that by itself add more of that?
I think that's a good question. When you have judges being paid by the public system, you're either going to be paying for the time of one judge or another. Now, you could argue that if the judge who's been working with the case pre-trial already knows that case, that they're going to be more efficient in settlement, or that they would learn things in settlement that would make them more efficient in trial. I would argue efficiency here is not as important as having faith in the system and knowing that it's working fairly. And I just think that we're not talking about giant costs here. There's going to be some more scheduling difficulties and maybe some inconvenience and arrangements about who you're sending the case to for settlement. But that strikes me, maybe naively, but it strikes me as manageable. So. Okay, thank you so much for
Fascinating questions.